Hello everyone and welcome to the fourth video on statutory interpretation. Today's video is looking at the mischief rule of interpretation. And just to remind you then that there are actually four approaches to statutory interpretation. So in our first video I did an introduction to the topic. In the second video we looked at the literal rule, and in the third video we were looking at the golden rule to interpretation. But today's video, we're going to be looking at this one, at the mischief rule. And as always, it makes sense to start off with a definition. So the mischief rule definition here in purple, the judges look for the mischief the act was designed to remedy, and then they interpret the act in such a way that a remedy is achieved. The best way for me to really explain this definition to you, I think, is to give you an example. So the example that I'm going to use today is the Abortion Act from 1967. So this Act of Parliament makes abortions legal. And before this Act, before 1967, it's hard for us to imagine, but abortion was completely illegal. You simply couldn't have one. So the law before the Act was that it was illegal to have an abortion. And because abortions were completely illegal before this act, there was mischief, there was a problem. And the mischief rule is talking about, why did we introduce an act? What was the mischief we were trying to get rid of? And with the Abortion Act prior to this, there were illegal abortions taking place. Because before it was legal, you can imagine that there were desperate women who wanted to have access to abortions but weren't able to. And quite often these desperate women would have what is sometimes referred to as a backstreet abortion or an illegal abortion. And those backstreet abortions were pretty horrific. Without going into details, horror stories about abortions being attempted with coat hangers, with boiling hot baths, women throwing themselves downstairs, really desperate measures. There were also, unfortunately, unscrupulous doctors and gynecologists who were willing to charge women £90. The equivalent today would be about £2,000 to carry out a backstreet abortion where incorrect procedures, unsterilised equipment was being used, women were bleeding to death. There was a real crisis. And it was because of this terrible situation of the backstreet abortions that led to the Abortion Act being passed. So as I said, the Act makes abortions legal as long as they obviously follow the rules of the Act. And the mischief that Act was designed to cover was backstreet abortions. And we're going to come back to the abortion issue a bit later in this video when we look at a famous case called RCN and the DHSS. But for now, hopefully that just explains what we're talking about when we're saying that judges are looking for the mischief the Act was designed to remedy. We're really just looking at why the Act was created, really. And our first case here is a really ancient one. It's from 1584, as you can see, and it's Haydens' case. And this case is important to us because in this case, the judge said that the following 3 points should be considered when using the mischief rule, and you will need to learn these. So firstly, what was the law before the statute was passed? Secondly, what was the problem or the mischief that the statute was trying to remedy? And thirdly, what remedy was Parliament trying to provide? And that's sort of what I was just talking you through with the abortion situation. We're looking at what the law was before, abortion's illegal. What was the problem? There were backstreet abortions. What was the remedy? Well, the remedy in terms of the Abortion Act was that abortions would be legal in a properly controlled medical setting. So on to the first of our cases then. We've got the case of Smith and Hughes from 1960. This case was all about prostitutes. And these prostitutes were charged with soliciting, contrary to the Street Offences Act of 1959, which made it an offence to solicit in a public place. Now, what these prostitutes were doing was that they were basically being a bit of a public nuisance, really. They were calling from balconies, tapping on windows, trying to attract people to take advantage of their services. So they're being prosecuted under this act, and the words that needed to be interpreted were public place or street. Now, these prostitutes were pretty savvy, and they were aware of this law that made it an offence to solicit in a public place or a street. So you can see here that they were actually calling from balconies, a bit like this lady here. They were tapping on windows. And when you think about that, they're actually in private. They weren't technically in a public place or street. So if we were using the literal rule of interpretation here, they're not literally in a public place or street, they're still in their houses, they are in a private place. However, the judges in this case decided that our prostitutes were guilty. And the judge here said that the activities of the prostitutes were held to be in a public place or street, even though technically they were in private, for the purposes of the act. And the judge said that this avoided the mischief of the effect of soliciting on passers-by. So the judge here, really what he was saying was the whole point of the Street Offences Act, it was trying to get rid of the mischief of solicitors upsetting passers-by. It was trying to prevent that from happening, from them soliciting in this public place. That was the mischief. It was upsetting people. It was a public nuisance. So they said in order to remedy that mischief, that they were held to be in a public place or street for the purposes of the act. So this does seem a little bit harsh on the prostitutes, really. And one could perhaps argue that maybe the judge's own prejudices, perhaps, on prostitutes might have come into play in this decision. Again, I think it's showing the unfairness that if a judge had been using the literal rule, these prostitutes would have been not guilty. But because the judges decided to use the mischief rule, then they're guilty of an offence. And that shows that it's not always going to be easy to advise your clients, because you can't necessarily predict what approach a judge is going to use before the case. And this is where I would like to move on to consider our second mischief rule case, the case to which I referred to before, RCN and the DHSS. Now, RCN stands for the Royal College of Nursing, but it's fine to abbreviate it for the exam. So this case was really, really interesting. It was about the Abortion Act. And in this case, we had nurses who were working in a hospital that were giving out abortion pills to patients, obviously under the instruction of doctors. Now, an issue arose where we realised that the Abortion Act 1967 states that, quote, and the words to be interpreted, registered medical practitioners can carry out abortions. Now, a registered medical practitioner means a doctor, and it can only mean a doctor. It isn't a nurse. So the meaning of these words, this phrase, is quite clear. So the Abortion Act says that abortions can only be carried out by doctors, and yet nurses were giving out abortion pills. Now, if we were using the literal rule here, then the nurses would be guilty of an offence, because only doctors can carry out abortions. So this was potentially quite problematic. And this case went all the way to the House of Lords, and that's what HOL stands for. And remember that the House of Lords used to be our highest court before it was replaced in 2009 by the Supreme Court. So the House of Lords in this case decided to use the mischief rule. And the judges said that the mischief to be avoided was illegal backstreet abortions with no medical care, and therefore the nurses were acting lawfully in giving out the pills. So to come back to what I was saying at the start of this video when we were talking about how the mischief rule works, when a judge is using the mischief rule, he looks at what was the law before the act. So before the Abortion Act, abortions were completely illegal. The mischief that we were trying to get rid of was unsafe, dangerous backstreet abortions. And the remedy that Parliament was trying to provide was to make safe medical abortions legal in the circumstances described by the Act. So what the judge was saying here was the Act was just trying to make abortions safe, and that abortions were taking place in hospital under the direction of doctors. So although the Act actually said registered medical practitioners, the House of Lords decided that the nurses were able to give out the abortion pills. But this was a really interesting case because not all of the judges agreed. We had a majority decision in the House of Lords that came down and said it would be lawful for the nurses to be giving out these pills using the mischief rule. But not all of the judges agreed with that. Some of them were of the view that this was infringing on separation of powers, on the sovereignty of Parliament, that judges were in essence making law here and ignoring this clear wording from the statute. And we'll come back to that point when we look at the disadvantages of the mischief rule. But as we've done for the other rules, we will start off by looking at the advantages of the mischief rule. And what we've really seen here through the cases is that the mischief rule is trying to give effect to the true intentions of Parliament. And it's promoting the purpose of the law because they're looking at what was the law before, what were we trying to achieve. And it's more likely to produce a fair or a just result. The Law Commission have described the mischief rule as a, quote, rather more satisfactory approach than the other two rules. So that's good to put in an essay to say that, according to the Law Commission anyway, that this is preferable to the literal rule and the golden rule. Lord Denning was also very much in favour of this approach, and we know that Denning liked to do his own thing. He liked to make his own decisions, and in his words, he felt that the mischief rule was advantageous because it allows judges to, quote, fill in the gaps. So he's making the point there that Parliament, when it's writing a law, can't envisage every possibility that might come up in the future. And in the RCN case, of course, it's interesting to think about the fact that abortion pills had not been invented in 1967. So there was no way the parliamentary draftsman could have envisaged that situation. So what Denning is really saying is that he's able to fill in the gaps between when the Act was made and the new circumstance in front of us today, which links to that last point there about the law being able to develop and adapt to changing social and technological circumstances. As always, though, there are disadvantages, and the big criticism of this rule really is that it gives judges too much power, because in essence, judges are making law really when they're applying the mischief rule. Lord Simmons criticised the rule, and you've got a quote from him there, which is nice to throw into an exam. If a gap is disclosed, so he's referring to Denning's comment earlier, the remedy lies in an amending act. So what he's saying there is it's not for judges to start changing the meaning of words or adding new words in. He's saying if there is a problem, i.e. that, nurses are giving out pills and we never imagined that before, then what we need to do is we need to get Parliament to create an amending act that's going to fix that problem. And that's because of this infringement of separation of powers. I mentioned earlier it is possible that judges might be bringing their own prejudices to a case, potentially. Maybe that was the case in Smith and Hughes. And also you can think about the fact that finding the intention of Parliament's not easy, even if we use Hansard. And another disadvantage is that you've got uncertainty, confusion, We don't know when the judge is going to choose to apply this rule.